What's up, people? Jonathan Wiseman here with another episode of JWise Live. Today, we're going to be talking about non-disclosures and expungements. And I have today from erasemyrecords.com attorneys Pheobe Smith and Shawn McDonald. And we're about to dive right into this, right?
Right. Sounds good.
All right, cool. Let's dive into it. All right, so expungements and non-disclosures has actually been a hot topic going on right now. There's a lot of buzz in the legal industry with it right now. So why is that happening? What's going on?
Well, the legislature made some changes that really enable groups of folks that could never have gotten an expunction or even more widely a non-disclosure, they can now get one. So, and that kind of, there's been a change, I think, probably to not mark people for life that have only been in trouble one time, so that they can actually get their record sealed and not have to worry about not being able to get an apartment or having a criminal history search done or anything, or just their criminal history being out on the internet. So the legislature has basically made these changes that allow folks that have gotten a single misdemeanor and have really not been in trouble since then to now get a non-disclosure.
Gotcha. Well, let's talk about the difference between the two. What is the difference between a non-disclosure and an expungement, or what is the definition of each?
So an expunction is essentially a destruction and erasing of your entire record. So it's gone forever is the easiest way to say that. So you can deny it's ever occurred. You can deny it on job applications. You can deny it in leasing apartments. It is a complete and utter destruction and erasing of your record, as opposed to a non-disclosure, which is just a sealing of your record that's only available to be seen by law enforcement. So anybody outside of law enforcement can't see your criminal record, but it's not destroyed. It's still there. It's just sealed to the general public, which almost for all intents and purposes, it's the same thing. And non-disclosures are much easier to get and more widely available than expunctions are. So we have always highly recommended individuals get non-disclosures because it almost serves the same exact purpose. You want to keep people from seeing it, and that's what a non-disclosure will do.
Gotcha. So an expungement is basically erasing the record, as where a non-disclosure is sealing the record. And when you say the law enforcement can see it, does that also include the courts? Or is it if you get pulled over for a traffic violation and they're able to see everything? What would be the difference in that? Or for the non-disclosures, when can they actually see the record?
So it's available to law enforcement, police officers, to prosecutors, to judges, to probation officers. They can see your record in the event you were to get into trouble again. They can see that you've had a problem in the past, so they could potentially use it against you. So it's sealed to everybody but essentially individuals involved in the government system.
Okay.
And I also think that it's the licensing boards, too, which are essentially associated with government agencies. Okay. Nursing board, the Board of Nursing Examiners, Board of Law Examiners, those folks are also still able to see if you've had something non-disclosed.
Gotcha. And I asked, I shot a little video of this before we came in today, and I had a lot of questions from a lot of different people, so we'll get to those at the end of the show.
Okay.
But one of the biggest questions is, who's qualified to get an expungement? And if they're not qualified for an expungement, then who would be able to get the non-disclosure?
So expunctions qualification, just in general terms, means you were found not guilty. The case was dismissed, the case was no billed by a grand jury, or you participated in a pretrial diversion program or a veterans court. Those are kind of the categories. It means that you never were found guilty or placed on probation for any type of offense and it ultimately was dismissed. That encompasses the vast majority of expunctions.
Okay.
As opposed to non-disclosures are typically cases where you're placed on a probation or a deferred, you successfully complete it, and you've never been in trouble before nor after that offense, they allow you to then seal it. So expunctions are, it's dismissed, we're going to erase and destroy your records. Non-disclosures are, you were placed on some type of probation and you successfully completed it and you stayed out of trouble for quite some time, we're going to allow you to seal those records.
Okay. So if somebody got a gun charge and they were found guilty, is there any way for them to get expunged or non-disclosed?
Gun charges are a little bit tricky, and in a lot of occurrences, no. With a gun charge, if you were found not guilty, then yes, of course, you get an expunction with that. If the case was dismissed on lack of probable cause, then yes, you could get an expunction. But let's say you got a probation, you did a probation on a gun charge, then I don't believe that a non-disclosure would be available to you.
For the different types of probation, would deferred adjudication fall under those guidelines?
Yeah, deferred is one of the two types of probation. So deferred is exactly that. A judge defers adjudicating someone, so that guilty plea that someone enters just sort of magically hangs in the air until they complete probation. If they don't complete it successfully, then a judge can then actually adjudicate them, versus a straight probation, which is you plead guilty, you're found guilty, but rather than being sent to prison or jail, you are placed back out in the community, but you still have a conviction.
Okay. So regardless, you have a conviction, so you can't get...
Well, not on the deferred. The deferred keeps you from having that conviction. That's the secret there. But it's also got a downside, which is the full range of punishment is left open. So the deferred is, as long as you make it, it's great. It keeps you from having that final conviction. But what is on the books, as far as that goes, is that you were once placed on a criminal probation or criminal deferred probation.
So let's separate the two. If you were on deferred, can it be expunged?
It can't be expunged. There's actually a criminal code that says you cannot expunge a deferred,
Okay.
but it is possible to get it non-disclosed.
Okay. If you're on just regular probation, is that something that can be expunged?
No,
Okay.
no. Expunctions are limited to cases where really there is no guilty finding one way or the other.
So, and when you go to court and, you start to get a record, you get arrested, gun charge, marijuana, whatever the case is, does that immediately go on your record so it's there for everybody to see?
If you're arrested, it goes on your record through DPS. So it'll always show an arrest regardless of what happens to the underlying offense. So that's what we tell people is if ultimately your case gets dismissed or no billed or you do a pretrial diversion and they dismiss the case, it's still going to show on your criminal record as an arrest, even though the case was dismissed. It may even sometimes show a dismissal, sometimes it won't. Unless you do a non-disclosure or expunction, that's always on your record. It's always going to show an arrest. So that's why it's always so important anytime that an individual has a background investigation run on them, it's going to show as an arrest and they're going to have to explain it. And if it's a high-level felony offense, even if they were innocent of it, they're going to have to explain it. And, frankly, if you have two candidates applying for the same job and you have one guy who has a third-degree possession of controlled substance case and the other one doesn't.
So that's really what expungement is about, is not necessarily the arrest or the plea or what you're found as. It's more about first getting arrested and it immediately going on your record. And if you were not found guilty or had it dismissed, then you want to get that pulled from the record so others can't see it.
Right, and that is a key thing with an expunction is the qualifier of being arrested. And of course the courts have sort of, there are some occasions where just simply exposing yourself to the authority of the court counts as an arrest. So let me give you an example. Let's say there was let's say that I was arrested for a theft and I was misidentified. It wasn't me at all. All right. But I still was arrested. And in fact, let's say this was a felony theft and they took me in front of a grand jury and I was no bill because I had a good lawyer and he was able to show that it wasn't me, but it was someone else that, looked like me or somehow was misidentified.
And what does no bill mean?
No bill means that a grand jury says there's not information to hold this person over for trial.
Okay.
Okay. So let's say all this happened in Fort Bend County. All right. And if you were to get on the Fort Bend County District Clerk's website, even though I was no billed, okay, even though that a grand jury said no, there's not enough information to even hold this person over for trial. We're trying, their mistake has been made or whatever. You would still see my name listed under for a grand jury no bill.
So it would be associated with those type of charges.
Right.
Yes.
Until you get it expunged.
Correct.
So when you do an expungement, the records are just completely erased. More so for the process. What do you have to do in the expungement process? Because once it goes up on everybody's computers and it's there, what is the process of you going through an expungement? Like versus if I were to try to do it myself or any individual, what is the difference that you do as attorneys to get that not just officially expunged, but actually removed from all of the different softwares, computers, agencies, anywhere else that's going to be. Is that a process that you do that typical individuals can't do?
Filing under the right statute and exceptions and qualifications under the statute. So you could file under the wrong expunction section that doesn't fit the facts of your case. And so private individuals will file an expunction, but it'll be rejected, and they're never told why it's rejected. It's just rejected. They don't think they're eligible anymore. Or they file it, and it is accepted, but they don't list the appropriate authorities to serve with the expunction order. So say they serve half of the people who have copies of the records and not the other half. Well, that other half out there is still uploading that information to databases.
If I'm an individual, can I get my own record expunged? And would you recommend that or not?
I would say you can try, but I definitely wouldn't recommend it because it's not a cookie cutter process. I mean, if it were, fill in these blanks and turn it in and this is going to happen, then that would be easy and that's what people should do. But there are exceptions, even things like what's called a TRN number, okay? There's certain numbers and things that we know that you have to get in order to get to DPS and get everything destroyed, get all these records destroyed. And it's just very hard to do if you are not familiar with the system, is what it comes
there's
down.
so many intricate, Phoebe and I both have, I have a binder, I have a book on expunctions and non-disclosure that I have went through, and we spent hours going over these things, trying to streamline the process and make sure that when clients reach out to us, we're doing exactly what we need to do to get these expunctions or non-disclosures done efficiently. And it's taken us hours and hours and hours, and we still, sometimes are referring to our notes and referring to the books, trying to find the solution to these requests for expunctions and non-disclosures. It's very voluminous.
Well, and as you were saying earlier, somebody might try to, and they might submit it to 2 agencies for dumbing it down purposes. They might submit it to 2 agencies that they know of, but not the other 12. So everything is still out there for everybody to see.
And it's when something like that is done, it's almost impossible to correct because the records usually at the district clerk's, in the district clerk's possession are destroyed and they don't exist anymore. So then you go back and try, it's like multiplying by 0. You try to go back and correct it and it's almost impossible to do. So it's one of these things you really have to get correct the first time.
Yeah, if you don't do it right the first time, you've got a problem.
So it's better to hire somebody to get it done the right way the first time.
For sure.
I can see how that could be an issue. You get half of it done, it's disappeared. So how do you go back and find it?
That's
exactly.
right.
If it's not in half the computer systems.
Right.
So then you don't know what's there or what's not.
Right. Let's say the same scenario where I've been accused of a theft and I'm going to do the expunction myself, and the only 2 agencies I cite are Fort Bend County Sheriff's Office and let's say Missouri City arrested me. Okay, so those are the only 2 I'm aware of, right? So those are the only 2 I put on the expunction to have their records destroyed. Well, what I don't know is that DPS has records. DPS is in charge of getting the records to the FBI. All of those agencies, once those records are destroyed in Fort Bend County, how do I get DPS to destroy them? Because they no longer
cut the cord and there's nothing no trail.
The balloon is gone.
Yeah.
And then there's agencies, while you're on bond, if you're reporting for drug testing, or reporting once a month to check in with a pretrial services officer. There's different agencies you have to serve in that, because now they have a record of you and what your charge is and that you've reported and shown up for drug tests, and so you have to serve those agencies.
As well as the same when it comes to trying to get a lease or an apartment or buy a house or run credit checks. So if you don't have a list of the 50 different people you need to contact and the right way to do it,
correct,
you're going to be stuck.
And it's, a lot of times we'll get a case expunged, but someone goes to rent an apartment and it's still showing up. Well, we then have to find out what agency they're running the background investigation through. We then send a letter from our firm with our letterhead on it with a copy of the order of expunction and letting them know that there's a civil penalty associated with not destroying these records because there's a court order. And so then they do it. But the average citizen won't know that. They're like, oh, well, they found my criminal record. I guess I'm going to have to move on.
Yeah.
Well, if we represent you, all you do is make a phone call and say, hey, look, my criminal record showed up. We'll handle it within 7 days, 5 days. We'll serve this company, and they have to take it down or they're going to be fined civilly for each day that it remains on their system. So, it's not something that we get your case expunged and then we walk away. We'll continue to be there for you and make sure that this criminal record doesn't appear on other search databases.
And when somebody does get an expungement, does it show up saying that they had an expungement or a record was expunged, or is it just completely blank and clear?
It is blank and clear. In fact, the statute even says you can lie about ever being arrested.
Wow.
It's a license to lie. So the only time that if you haven't been granted an expunction, the only time you have to say anything is if you were testifying in a criminal matter in a court of law and someone were to ask you about it, and the only thing you would have to say at that point is this matter has been expunged.
Gotcha. That's
It's a
good.
powerful thing.
It is.
It really is.
It really is.
And it should be, because it's trying to take somebody back to the day before basically a mistake was made.
Absolutely. They could be very well be not guilty of the crime that they're charged with.
Yeah.
And without an expunction, even
Yeah.
if you were not guilty and falsely accused and everybody knows it, it still stays on your record
And
unless
I
you do
didn't-
something about it.
Right. And I meant a mistake by law enforcement in arresting somebody, or a mistake of, of
Sure. No, I get it. Yeah, for sure. When somebody needs to get an expungement, if I've got a record, I was not guilty, I want y'all to expunge it, how long does that process take before it's removed from my record?
There is some waiting periods depending on the circumstances behind the offense, largely dependent on the county that you're seeking the expunction and how efficient they are. But here in Fort Bend County, if the waiting period is up and you are eligible for an expunction, it'll take us about 30 days. Is that about right?
Yeah, that's
From the time they call us till we get it filed, and then the waiting period to serve these agencies to see if they have any objection. You're 30 to 45 days
To have the record cleared.
to have the order signed.
to have the order signed. Now, the statute also gives them up to the agencies that have materials, they have up to a year to turn that in, or send in a certified letter saying we've destroyed these materials.
Because some of the questions, and I had a lot of them flying in, and most of them were related to either getting hired or trying to rent an apartment or a home.
Mm-hmm.
I would say real estate background check people are the biggest offenders when it comes to misreading criminal histories, not knowing what they're reading, but also, just it goes back to Shawn's example of, you've got somebody that may or may not have a possession case in their background versus somebody that doesn't. The easy choice is to go with somebody that doesn't.
Yeah.
Mortgage companies, are they willing to take that risk? They know you have a felony arrest. Well, are they going to take a risk knowing that you've been arrested for a felony? That in their mind thinks that there's a greater chance you're going to commit another felony. And are they going to risk you potentially going to prison and they're stuck holding the mortgage because you can't pay it because you're in jail? So mortgage companies take a very good look at your criminal history, because if you got a long criminal history, that's a higher risk for them.
And so if you're unable to get something expunged related to the real estate industry, mortgage, renting, or what have you, when it comes to non-disclosures, what are they able to see versus what is sealed to where they can't see it if somebody can buy or get a loan or to rent?
If the non-disclosure is granted, then they shouldn't be able to see anything on it, because they're not one of those law enforcement organizations connected to the courts or licensing boards.
So they won't see anything.
They shouldn't.
And if for whatever reason they do, if they hired y'all in the first place, then they'd come back to y'all and y'all would make sure it gets
Absolutely.
dropped. What is it typically going to cost somebody to get a non-disclosure?
You're looking approximately $1,500 plus filing fees of about $350. So you're looking south of $2,000.
South of 2,000 to change your life.
Mm-hmm.
That's crazy. That's not bad at all.
Not bad.
No, it's not.
I mean, talking about trying to get an apartment, trying to get a job, you can't really.
Car insurance. How much are you overpaying in car insurance because you have a DWI conviction that they find every time they quote you a price?
Yeah, I didn't even think about that.
Yeah.
You can probably save money all over the board.
Absolutely.
It'd make more sense to get it and drop it. Well, and I know in the real estate business, if you do have certain things on your record, they want a double deposit or triple deposit because they don't trust you.
Of course.
Right.
Has there been a change in the law that will help people that have had a DWI?
Yes. About 3 years ago, the legislature allowed for DWI convictions and or deferreds to be sealed. If you were never in trouble before the DWI and you haven't been in trouble since, there is a waiting period depending on the circumstances of your DWI, but you now can seal your DWI conviction that you used to not be able to have sealed because of the change in the law.
So beyond 3 years ago or 5 years ago, you couldn't get an expungement, you couldn't get a non-disclosure, you couldn't get anything.
You probably could, if the circumstances were correct, you might have been eligible for an expungement, meaning that you were found not guilty by
Sure.
a jury. But if you pled guilty and were placed on some type of probation, or even if you went to jail 5 years ago, you could not have gotten a non-disclosure.
But the law has changed
The law
to
has
where
changed.
now you can.
Right.
Pending
So
the
if you even got legal advice at that time saying, no, you can't get this non-disclosed, ask again. Research it, find out, because you might be eligible. And it's a big change.
And it's as simple as this. If you had a DWI and it's a one-time offense and you've never been in trouble other than that one-time DWI, you are eligible for a non-disclosure. It's as simple as that. As long as you've never been in trouble before, you are eligible to have that DWI sealed.
Or after.
Or after. Yeah, you have one-time offense. That DWI can be sealed.
Previously, like for instance, when I first started practicing law, you could not even get what we call a deferred probation for a DWI, and now you can do that. There's also a lot of pretrial intervention programs that are also available. But like anything that begins with an arrest, there's going to be a lot of paperwork behind it, and that's why you need to get it non-disclosed. And before. You could not get a non-disclosure on a DWI. Now you can get them even if you've been to jail. And as long, really, what the non-disclosure law looks at, I think more closely now, is your behavior after the offense. Did you continue to get in trouble, or was that your single wake-up call where you having a bad 48 hours or something where you made some bad decisions, but you saw that and you changed your behavior, and you haven't been in trouble for 5 years, even though you did go to jail, you took a conviction even. If you wait 5 years, now you can get a non-disclosure. So that's an amazing change.
And it's one of the few exceptions that for a conviction, a DWI conviction, most of the time if you get a conviction, you're not eligible for a non-disclosure. But DWIs, there's an exception. Even if you are convicted of a DWI, you are entitled to a non-disclosure. So the legislature, I think, saw that there's so many DWIs, unfortunately, committed, but they're just one-time offenses. The individual learns their lesson. They never were in trouble before nor after the offense. We think it's appropriate not for that DWI conviction not to follow them the rest of their life. We're going to give them the opportunity to seal it and move on.
So in summary, if you got a DWI, you wait 5 years, then you can get your record non-disclosed to where it's sealed.
Well, 5 years is the long waiting period. That's if you went to jail and did a time served, or something. Like an example, like I get arrested for a DWI. Shawn represents me, and he works a deal where I get 3 days in jail for the 3 I've already served. I take a conviction. I go on my merry way. That is a 5-year waiting period. All right. If I had done a probation and had an interlock device on my car, then I could actually get a non-disclosure in as few as 2 years after my probation was
Gotcha. And is that because you didn't do any time?
And I had the interlock device.
And you have the interlock.
Right.
So there's some little clauses in
There
there
is.
are.
that can...
So just imagine the number of DWI convictions and probations that have been completed in the state of Texas that are on individuals' criminal histories, and they've never were in trouble before the DWI, nor have they been in trouble after. All of those individuals are entitled to a non-disclosure and can seal that record. I mean, there's tens of thousands of individuals who, let's hope they learn their lesson, they're not going to put themselves in that position again, and now they're eligible for a non-disclosure.
That's amazing.
And they're just not aware of it.
Yeah.
And it's because of recent changes in the law that, you have all of these individuals who can seal the record that's been following them for 10, 15, 20 years.
That's
Right.
crazy. So I had 2 people reach out to me today that had DWIs, and one was from like 10 or 12 years ago, they said, and they can't get an apartment because they have that on their record.
I've heard of that. I've heard of people being stuck in a job and didn't feel like they could move to a different job because they didn't want to have to go through a background check, and they didn't want to have that conversation about the DW I got when I was, 19 years old and then in college.
Or they're driving a vehicle for a company, and they won't let them drive a vehicle because the company insurance won't cover them because they have a prior DWI conviction in their background.
And you can have that sealed to where nobody can see it, and then
That's right.
they continue on
That's right.
with their job, with their driving, with their life.
Right. It really is a huge change. And it's, one of the reasons we started doing this because this could change you could change your life by getting a non-disclosure. You get your freedom back, your freedom to make decisions on what job you want, where you want to live.
And it's literally all it takes is a click through on our website, which I'm sure we'll talk about. It's a click through. we determine if you're eligible. If you're eligible, then if you want it to be non-disclosed, you pay the fee, and we do everything. You don't even really have to talk to us.
It's
You
just
can-
all automated.
Absolutely. It's almost all automated, and then we draft the paperwork, we file it, we appear in court for you, and then six weeks later, we send you an order of non-disclosure, and it's sealed.
That's simple.
Yeah,
That's
it's,
easy.
it's not a difficult thing for you to do and take advantage of.
What are some of the things that you've seen where a DWI on somebody's record has kept them from being able to do something in life?
I've had folks that are afraid to move to a different job because they don't want to have to go under a background check. So they may not like their job but they feel like they're stuck. And that's horrible. That's almost like a prison sentence. So
Yeah.
And I think there's a stigma attached too in people's minds, even subconsciously, is I'm a criminal. And I think that stigma, and I think there's probably quite a bit of literature out there about once you have that stigma in your mind that you're a criminal and you break the laws, the next time you break the laws is a little bit easier. So I think it's kind of a fresh restart for people like, oh, okay, I have a fresh start. I can act like this never happened. This is sealed. No one will ever know. I don't feel like I have this stigma attached to me anymore. And I think that does a lot for people's psyche, frankly. I really do.
And think about how that stigma is reinforced, because every time you go fill out a job application, every time you fill out an application, you get an apartment. What does it say? Have you ever been convicted of, anything now, really?
And a lot of people lie, and they don't want to put down they got convicted DWI because they think it may cost them a job. So they lie. Well, then they get caught in the lie, and they don't get the job.
And then it looks worse.
That's right, and it just starts snowballing. So now you get it sealed, you can deny.
So what should somebody say if they get an expungement of the record or they get a non-disclosure? What should somebody say if they're asked if they have a record and it has been cleared by one of those?
The code on expunctions is very, very clear. You can actually, if you get an expunction, which again is different than a non-disclosure,
Sure.
but an expunction destroys the records, you can deny ever even being arrested. In fact, the only time you have to even say anything different than that would be if you were testifying in a court of law, in a criminal matter, and someone were somehow able to find out about it, then the only thing you would have to say is that matter was expunged.
So
That's it.
other than being in a court of law,
You can deny it.
you can deny it.
You can deny being arrested. It's a little bit different with a non-disclosure because the records still are there, but they're sealed.
So what should somebody say if they're asked if they've ever been convicted of a crime, but they have a non-disclosure sealing their record?
If the non-disclosure is done correctly, the background investigation should never reveal it. But if it's not done correctly, or someone does it themselves and doesn't discern the appropriate agencies, then it will appear. So it's a
Let me use an apartment as an example. If I got a non-disclosure with you guys about a DWI that I got a few years ago, and I'm filling out the application that says, have you ever been convicted of a crime? Can I say no?
I wouldn't necessarily advise to lie about it because technically you have. It's just sealed, unlike an expunction where it's destroyed and you can say you've never been convicted. I wouldn't advise lying. But I think if you were to disclose it and they run a background investigation and it doesn't appear, I think that's certainly much more beneficial to you than if you were to disclose it and then they brought it up and showing you've been convicted. So,
Well, and I think those are the two biggest places it would happen, for a job or for trying to get an apartment or a rent or
Right.
lease or something along those lines. And I know y'all are lawyers and you have to advise us in a certain way, but for those of you listening, if you're going for an apartment or you're going for a job and you've got a non-disclosure hiding or sealing that record, I personally would say I never had a record. Now, I know these two would not lie, but I would in that case. So just trying to make it clear for the audience.
that's fair.
People are wanting to know, if you get an expungement, will your criminal history, will everything be sealed, or is an expungement kind of case by case on what is taken off?
An expungement is very specific to a particular case, okay? Because again, that one, an expunction is going after either you've been found not guilty, okay? So the record they're destroyed at that point, okay? Or if you were arrested and there was no probable cause, then of course those records are going to be destroyed. You can also, of course, if you were no billed by a grand jury, those records would be destroyed. So that you can deny.
Well, because there's some people that might get 4 charges at one time, or they might get a charge this year and 3 years prior they got a charge on something and they did time, so they got a criminal record. And they might go get one of those expunged and go through the process. Just for clarity, if you get one offense expunged, then it doesn't clear the rest of your record.
No, it's
Correct.
very, and you kind of brought up one of the things, like if you get arrested, you get pulled over, you get arrested for possession of controlled substance, DWI, and you plea on the DWI, then you cannot get, even if the possession was found out, that it was like chalk, not cocaine in your glove box, you cannot get that expunged because you pled on the DWI.
Yeah, so that was one of the questions I got today. It's crazy how many questions came in. Somebody got charged. They had a gun on them, unlawful possession of a firearm, and they had weed with them, marijuana. And so they said that they got the weed charge dropped, but they were unable to get the gun charge dropped. So does that mean they can't get an expungement on either of those charges?
Correct.
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 We deal with, the term of art is called criminal episode. So if you've got cases coming out of the same criminal episode, you plead guilty to one, you can't get anything else expunged, even if it's like the chalk and the cocaine thing, even if it's completely.
Gotcha. But it is possible to get a non-disclosure on those.
Depending on what kind of
The
probation you did,
circumstances.
potentially, yes.
Yeah.
Well, let's dive into some of those charges, because people are going to want to know, okay, if I have a gun charge, can I get that expunged or not? Basically, if you have if you pleaded guilty, you did time. For the most part, you can't get an expungement.
Or a sealing. Essentially, if you're found guilty of an offense, whether you're placed on straight probation or you're sent to prison, meaning you pled guilty and you were found guilty. So jail time, straight probation, prison time, you can't get it expunged or non-disclosed, with one exception, maybe a few others. But DWI is a big exception. If you were found guilty of DWI, you're still entitled to a non-disclosure. Expunctions, think of if my case was dismissed. Think of I wasn't held accountable for this offense at all. For a variety of reasons why it was dismissed, if it was dismissed, chances are you're entitled to an expunction. If you were placed on a deferred probation, you successfully completed it, you're going to be probably eligible for a non-disclosure.
Okay.
But again, you're found guilty, jail time, prison time, you're not entitled to either.
I got you. And I know I'm asking the questions 5 different ways and sometimes repeating myself, but I know that different people ask that question differently in their head, and I want to make sure whoever's watching the full podcast that we're as fucking clear as we can possibly
Sure.
be,
Yeah.
so that we're answering their questions. Similar to the the gun laws video that we did on the last podcast. Y'all be sure to check that out if you're watching. There's 400, 500 questions, and a lot of those questions are asking the same question 10 different ways. So I want to cover that as much as we can for everybody that is watching.
And that's something our website will help you with. It's a click-through system that should, at the end, determine your eligibility if you know enough about your case, that you can just click through on our website and it'll answer your questions whether you're eligible or not for a non-disclosure or an expunction.
Gotcha. So what would qualify me to get an expungement of my record?
To be entitled to an expunction, you have to be arrested, number one. And either the case get dismissed after you start going to court, that they can't prove the case and they dismiss it. You participate in some type of pretrial intervention or pretrial diversion program, which are much more widely used than they were, say, 5 years ago. Or you are found not guilty by a jury when you went to trial. Those qualify you for an expunction, the erasing and destruction of all of your records.
Okay. And what would qualify me to get a non-disclosure?
To get a non-disclosure, typically for felony cases, you have been placed on a deferred adjudication probation, okay, which means you entered a plea of guilty, but you were not found guilty, and you got on this probation, you did everything you were supposed to, and then you were discharged from probation, and that case was dismissed. You wait 5 years, and now you can apply for a non-disclosure. On misdemeanors, there's a list of restricted misdemeanors, which doesn't mean you can't get it. It means you just have to wait a little bit longer. Same circumstances, placed on a deferred. You successfully complete that, case is dismissed. On the restricted ones, you have to wait for 2 years. On all other misdemeanors, you can get it immediately.
Gotcha. And when I go to your website, erasemyrecords.com, I go through an automated process, and it will tell me if I can get an expungement or non-disclosure and take me through that whole process?
It will take you through step by step. And if you still have questions at the end of that, then call us. We're both lawyers. We're able to answer questions and help you figure out if this is something that you can get that will help your life.
And a lot of people won't have enough records to work the click-through system because you're going to need the county, exactly what happened on your case, the cause number. If you don't have all of that and you don't want to spend the time trying to acquire it, then you can pay us, I think it's $199, and we'll do all the background investigation for you and let you know if you're eligible. We'll do all the legwork and give us a week, and we'll let you know if you're eligible for an expunction or non-disclosure, which I think a lot of people are probably going to do is pay the $200. I'll let them determine if I'm eligible or not. If I am, great, I'll follow through and get the expunction or non-disclosure. If I'm not eligible, then I've had an attorney do the check, and I'm going to trust what they're telling me.
Gotcha. So either way, go to erasemyrecords.com or call the number on the website, and they can find that out.
Absolutely.
Exactly.
Couple of questions from the audience. I'm just going to ask as they asked me. I got charged 10 years ago for weed and a pistol together. They dropped the weed charge and still charged me with a Class B misdemeanor for the illegal weapon. What are my options?
It depends on what happened on the illegal weapon case, the unlawful possession of a firearm case. Was it dismissed? Did he complete a deferred adjudication, or was he placed on straight probation, or did he do jail time? If it was dismissed, then yes, he's potentially eligible for an expunction. If he did a deferred,
If you got the deferred on the unlawfully carrying a weapon, it's one of the restricted ones, so it would be a 2-year wait.
a 2-year wait. Okay.
So after a 2-year wait, then possible.
So largely depending on what happened on the case,
Right.
the gun case.
We need a few more details to be
Sure.
specific.
Well, I'll tell them to call you.
But definitely worth looking into and trying to find out.
I had a Vicodin. I had a Vicodin in my car that I had a script for. I went to court and won the case, but it's still showing up on my record, both here in Texas as well as in Florida. What can I do?
Well, again, we need to know more details about the case. And in terms of I won my case, does that mean that the case was dismissed? If it does, then chances are, if the original offense occurred here in Texas, then I would think she's probably eligible for an expunction.
I would agree.
I would think so as well.
Worth every penny to look into it.
I'm just asking in their words. I have a felony drug charge from 1992. Did deferred, and I've been told it can't be expunged from my record. Is that true?
That is accurate. If he was placed on deferred, it cannot be expunged, but he's likely eligible for a non-disclosure, which would seal it, which would be highly beneficial to that individual.
Yeah, I can imagine.
Yeah.
And last one is I got charged for a felony gun possession 15 years ago. I got out of jail a couple years after. Can I get that expunged or non-disclosed?
Well, again, I would like some more details, but just based on what you've just
He was
said,
charged guilty. He went to prison
He
for a
went to
couple
prison.
years.
I would say no. Definitely not an expunction, and probably not a non-disclosure.
Gotcha.
Or I'm
Well,
pretty close to definitely not a non-disclosure on that one too. So.
Well, in your own words, just tell me why expungements or non-disclosures are just so important now with the laws changing, and why people should take advantage of them.
Well, a lot of it's based on the internet. I mean, criminal history is so much more available now to people than what it ever was before. I mean, you can pay a few bucks, for a single criminal search. I'm sure.
I've seen them, $6 and you can find out anything.
Exactly. So, it's important to, because that information is so widely available, it's important to control it. In a non-disclosure, if you're eligible for one, you deserve it, you should seek it, and limit the amount of information that's out there about you, especially something that most folks don't want out there.
I know I did some dumb shit when I was younger, when I was a juvenile, and got locked up, did some time when I was 16 years old. Is that still going to be on my record? Is there a possibility of that? And if so, would I need to look at expungement or non-disclosures?
If you were a juvenile, it should not be available for people to see. It's still technically on your record, but no one can see it. We typically don't even know about juvenile adjudications. If I'm representing a client, we typically don't even know. We'd have to do a lot more background investigation to even find it. So it's not readily available. And to hit on what Pheobe said is, I think that's why the legislature has made these changes in making non-disclosures and expunctions much more readily available, is because people's criminal histories are much more readily available. Literally, you give me 3 minutes and an individual's first, middle, and last name, and I can pull their criminal history in 3 minutes and tell you exactly where they arrested, what they arrested for, and what their sentence was. And anybody that's internet savvy, if you take a couple of hours, will be able to figure that out and can run a criminal background investigation on anybody for virtually free, $6. So I think the legislature is starting to recognize that this isn't 30 years ago, which the only way to know about a person's criminal history was word of mouth. And that didn't travel very far. Well, now everybody can get on the internet and find your criminal history. So they're like, that is costing individuals who made a one-time mistake. It's costing them dearly. And we want to be able to give them a remedy and not have these one-time mistakes follow them the rest of their life.
Is there a story that y'all have had within your firm that you could share with us or share with the audience?
I had a young lady who dated someone that, she thought she knew pretty well, but it turned out she didn't. He may or may not have had a little side business that wasn't exactly legal going on. She happened to be at his house when a search warrant was executed, and she was arrested. And she lost her job over this, almost lost her house when she lost her job. She had to, and we ended up actually getting the case no-billed, meaning a grand jury said no. She was just
collateral
wrong.
Damage.
Yes, exactly. So we, even though it was no-billed, prior to that, she was fired. And we were able to get her an expunction so she can work back in the same industry, not at the same job, but in the same industry. And that's a success story. But
absolutely.
But the downside is the fact that she was fired in the first place and shouldn't have been.
Yeah.
But I have a kid just last week. Went down to Padre or Corpus, Cameron County, when he was 17, 18 years old, and got in trouble for having some type of party drug. And was placed on a pretrial diversion, and he successfully completed it. It's in college now. He's about to graduate from college, is starting to apply for jobs, and his family called and said, hey, this is coming up in background investigations. Is there anything we can do? And I'm absolutely. We can get this expunged. He completed a pretrial diversion program. And the kid's about to graduate from college, never been in trouble before except for this one-time offense, and it's been on his criminal record now for 6 or 7 years, and we're going to get it expunged. And he's going to be able to deny he was ever arrested and, making a stupid decision as a 17, 18-year-old kid on spring break. That's crazy. And they were shocked. They're like, you mean we can destroy these records? I'm like, absolutely. Your son did the right thing. He did the pretrial diversion. He successfully completed it. And the vast majority of the times, the prosecuting attorneys will agree to it.
We're at a point now, I think, I think the legislature has realized this, that we don't need to cripple someone for life for making a decision in college, driving and drinking too much. Sure. Right? And think about how that's reinforced through your entire life. If you are, if you're 50 and you got a DWI when you were in college, how many job applications have you had to fill? Or even, let's say you want to go to graduate school. Well, guess what they ask for a graduate school application? Have you ever been convicted of any crime? And every time you have to fill that out, it's that second page, please explain. And you have to relive all those details over and over again of the worst decision you made or the worst night of your life. To be able to put an end to that, and that's what a non-disclosure can do. It ends that, and it gives people a new beginning. And that's what we want to see. That's what we want people to have.
Sure.
And we touched on it earlier, just people's psyche related to that arrest, and that which is likely the worst decision they've ever made in their life. It's defined them for 10, 15, 20 years. Because like Phoebe said, over and over again, they have to relive the worst decision of their life.
Yeah, everything you fill out, you're being reminded.
I mean,
please
yearly.
Explain.
Yeah. Then they want details.
Exactly.
And I can see that wearing on people.
Sure.
That, I'm essentially defining myself as a criminal for the rest of my life for something I did when I was 18 years old. And it was the worst decision I ever made, and I'm ashamed of it. But I got to relive it every single day.
And now please judge me once again for it.
Right, that's right. Now keep holding it against me 30 years later, 10 years later, 5 years later. Even though I did what I was supposed to do and I made that bad decision as right as I could, I'm still being defined by it.
Sure.
That's tough.
It is.
It's really tough.
I can see how that can take a toll. I've never thought about it like that. Well,
it's so easy to fix. That's why we're here, as Phoebe and I were like, we're doing so many more now than we used to, say, 2 or 3 years ago. And both of us are like, let's make this more readily available and have a click-through website where people can investigate and look for themselves to see if they're eligible, because we could help tens of thousands of people seal their records and give them a fresh start for, less than $2,000. That
Yes,
could be a lot of money to somebody, but in the end, it's not super expensive.
No, it's not that bad at all. And you said non-disclosures were going to run you about $1,500. Is it the same thing for an expungement, price-wise?
Expunction might be a little bit more just because of the costs are actually more to serve all those agencies that we were
Sure.
talking about earlier.
You have to serve them by certified mail, and so there's cost associated with that. But
What's the
we're talking
typical
less than
range?
$500 more.
So what's the typical range somebody's going to pay to get an expungement?
$2,000.
2,000.
2,000, 2,500, probably
So
something like that.
to get a non-disclosure, you're going to be in the $1,500 range. To get an expungement in the $2,200 to $2,500 range.
That's fair.
That's not bad to change your life.
No.
Not at all. Anything else y'all want to add before we get out of here?
I just want to really encourage people to act on it, because what the legislature giveth, they can also take away.
Well, and that's actually what I was going to ask. You were
Great
just
point.
saying over the last 2 years, you've started to get a lot more of these cases and help a lot more people. Is that something that has happened in the last 2 years because the law has changed?
Exactly. Because now more people, the pool has widened. There's more people eligible, whereas before it was a very small.
And that's,
Gotcha.
that's the change in the laws, as well as the change in policies amongst the district attorney's offices and giving pretrial interventions and pretrial diversions. 10 years ago, those were essentially unheard of.
Sure.
And now, if you're a first-time offender and you're a young kid, the chances of you getting a pretrial diversion on some stupid misdemeanor possession of marijuana or stealing a comb from Walmart, the vast majority of district attorney's offices are going to make that pretrial diversion eligible to you, which in turn makes an expunction eligible to you if you complete that pretrial diversion.
Okay. Got it. Well, and kind of like you said, Phoebe, if, they can change the law one way, they can change it in the other direction anytime. So,
Right.
Well, if you've been convicted or not convicted, if you've been arrested, right? Because convicted, you're fucked.
A good way to put it.
Kinda, yeah.
All right, cool. Let's wrap it up. Well, if you've been arrested and you have any questions about expungement or non-disclosures, go to erasemyrecords.com. And there's also a number on the website where you can call Phoebe and Shawn directly with any questions you might have. I appreciate y'all tuning in. I appreciate y'all coming on the show today.
Yeah, thanks for having us.
Thanks.
Absolutely.
Enjoyed it.
And I hope to get y'all back in here on a few more topics.
Absolutely.
All right.
Cool. Well, I appreciate y'all tuning in, and we'll see you on the next one. Take care, guys.